right. Welcome, everyone. Good afternoon. My name is Marc Ouimet-McPherson. I am a lawyer here in Ottawa. Very important today, just a few housekeeping things. My comments only apply to the laws of Ontario. So unfortunately, I'm not a licensed professional in any other province. However, if you are in another province that is not Quebec, everything is pretty similar throughout the country. So one quick statistics first before we start the workshop, just because often people think they're alone in not having made a will or not having planned, but anecdotal evidence shows that over 50% of Canadians don't have a will at this time. So don't feel alone. It is the right time is now to organize your affairs. People often take care of their affairs during their lifetime, but then completely forget about, okay, we are going to pass away, unfortunately. It's time to plan for it. So one reason, just a personal side for myself, and one of the reasons why I wanted to do this as part of the program is that a few important women in my own family didn't have wills, and this caused a lot of angst in my family. My own grandmother, who everybody assumed had a will because my grandfather had one, never did. So nobody ever actually thought to ask her. So that's why I do all of these seminars, is just to get the word out there on the importance of doing a will. So before we go through the handout, which I think you can get through the Whova platform, I just wanted to go through the top 5 reasons why you should have a will to illustrate the critical importance of your estate planning and why it should start today. So reason number 1, if you don't have a will, or if you do have a will, you get to decide. If you don't have one, unfortunately, the law decides for you. So this includes things like who will handle the executorship of your will, so who will take care of your estate. If you don't have a will when you pass away, the law dictates very specifically who will do it. And this can often lead, as you can imagine, to family disputes, which nobody wants to leave their family. Reason number 2, you choose the beneficiaries if you have a will. If you don't have a will, unfortunately, again, the law chooses for you. And just to kind of alleviate any misinformation that exists out there, if you don't have a will in Ontario and you pass away with a spouse, a married spouse without children, your spouse gets everything. However, if you are in the 50% of Ontarians who are common law spouses or partners rather, that person gets nothing if you don't have a will. So be very mindful of that. If you are a common law or in a common law relationship, it's even more important to have a will. Now, if you are married and you don't have a will, your spouse gets primary entitlement, and then will have to share part of it with your children, if you have any children, and so on and so forth. If you don't have any kids or a spouse, then it goes on to your parents, your siblings, and your nieces and nephews. And just a side note on these kind of automatic entitlements, it's very important to remember that the law doesn't mind or care, rather, if, say, everything is going to your children under the law. However, one of your kids took care of you, throughout your life, and the other one you haven't heard of in 20 years. If you don't have a will, those 2 kids will be equally entitled to your estate. So very important. The law is not caring. It's really just going to divide it between the people that it states in the law. So that's, if not the most important reason why you should have a will when you pass away. The other reason, so reason number 3, you get to choose who gets your personal effects. And this is often lost on some people, is that, if you have items that are, special to you, that maybe are special in your family, jewelry, art, collections, it's not necessarily the value of the item, but if you have a will, you can clearly state in your will who you'd like to entitle to those items. So people don't often realize that estate disputes, which I don't have time to talk about, but I'm sure you're all familiar with them in some regards. We all seen the movies and TV shows surrounding this. all those disputes often start surrounding personal effects. So it's not often the value of the item necessarily. It doesn't have to be a Picasso. It can be an old chair that you have, that all your kids would like because they remember sitting in it to read books when they were kids, or whatever the backstory is. Just be mindful of that. So this is a very important reason why you should have a will. Reason number 4, if you have minor children, you can choose your own guardian for those minor children in your will, and we'll come back to that in a few minutes. And reason number 5, you can leave intentions surrounding your burial, funeral, cremation. Obviously, if you have a will, you can lay that all out in the document. If you don't have a will, your family, your friends may not know what exactly you wanted. So if you have a will, this alleviates a lot of the stress on the executor, so the person managing your estate. Now, what do all of these 5 reasons have in common? And I think you've likely all figured it out. More importantly, when you have a will, it puts you in control rather than leaving it to the law. Now, I love the law since I'm a lawyer, obviously, but in this case, you really want to have control over who would benefit and who gets things under your will and under your estate. So let's go through the handout together. And I will share my screen if I'm able to here, just so we can go through it in case people maybe don't have access to this if they're on their phone presently. So oftentimes I get the same comments when people call me. It's an overwhelming process to go through the estate planning process, preparing a will, preparing powers of attorney. So I try to break it down as much as I can. Often for myself, a complicated thing, you just break it down in steps, and it makes it a lot easier and much more digestible. So number 1, if you're new to this, if you're new to estate planning, first and foremost, you should make an inventory. So what does that mean? As it shows, you should break down how you own your assets. Do you own any properties? How do you own those properties? Do you own them jointly with somebody else? Where do you keep your bank accounts, investments, electronic assets, life insurance, any vehicles that you may have? Very important in all of this is that there is no registry in Canada for any of this information. So if you haven't made an inventory before you start the plan, well, it's much more difficult to create a will in the first place, but it's much more difficult as well for any people coming after you if they don't have this list to help them, guide them through the process. So your executor will be very thankful if you've made an inventory. Very important as well, and as the handout points out, any registered investment and life insurance, and I'm sure you'll have a piece on this, make sure you have a named beneficiary unless they're a minor. Now that saves on taxes, and it's just much more tax efficient in that regard. And then action items, because I see it almost not on a daily basis, maybe on a weekly basis. If you're unsure about the beneficiary on an asset, please call your insurance company, the bank where you have your investments, just to make sure, A, you have a beneficiary, and B, it's still the person that you want on there. Because I see it often where, separated spouses will get a life insurance, for instance, where I'm sure the deceased did not intend to leave it to their separated spouse or the divorced spouse, but that's the way the beneficiary designation still is when the person passes away. So be mindful of that. Also in this inventory, you should, as I alluded to, put items of value. So it's not necessarily a monetary value, but also sentimental value. Is there an item that all your kids, grandkids, or family members or friends always talk about? Think of that item, and then later on we'll see, pick a person to which to give it to. Also very important in this day and age is, of course, the electronic assets, passwords, and things like that. Don't be like my parents. Don't keep a list of passwords on your desktop of your computer, but it's certainly a good aspect when you're making your inventory. Now, the flip side of all this as well is it is important to make a list of debts. Now, it's not necessarily only debts that you owe, but also debts to yourself. So who owes you money? Who do you owe money to? Have you co-signed with anybody? And we see this more and more. If you have any adult children, have you had to co-sign with them, on a property so they could buy it? Are you on title to their property? What's the intention there? Do you have any documents about that? These are all questions as well that a lawyer will go through with you when you're thinking of estate planning. But if you have it already all either in a document or at least ready to go, then it simplifies the first meeting you'll have with a lawyer, as well as trying to put things in perspective for yourself, right? Because sometimes we think, oh, I don't have that many assets or that many debts or both. But then once you start making a list of them, a lot of things come to the surface. Maybe it leads you to really see the importance of having a will. Now, one important aspect of the debts, especially if people owe you something, is how do you want those recognized in the will? So that's an important question as well. Now, in terms of things to think about, so that's A, once you've made the inventory, and of course, we don't have time to make an inventory today, but go through this list. You can use this list, print it out, make a list electronically. That's completely up to you. Now, after that, after you've made a list, here are key things to consider before you make a will and in preparation for. So first thing being, and very important, is who would you like to execute this will? So who do you want to take the time and be your representative, if you want, once you've passed away? So that is the executor role. And ideally, it can be a family or friend. It can also be a professional. Does not need to be the closest living relative. And I often have this debate with my clients and even with my own family. I don't want to call it a common mistake, but often people say, okay, well, I have to name my eldest child as my executor because they're my eldest child. Not necessarily. It is completely up to you. And is your eldest child the most qualified person? So sometimes it's best to look outside of our family nucleus, look at friends, look at family that's maybe a little bit more further away from you in terms of familial link. And that person may be better suited in terms of, fulfilling that executor role. Very important is that you speak to the people you want to name, and important as well is that you think of a few different people. So if you want to think of a primary person, a secondary, and then a third, and I mean, it can be a longer list than that, but ideally you have 3 people there that wouldn't act together, but one after the other. If one of them couldn't act for whatever reason, that person could renounce, and then that role falls to the next person. So that's a first important thing to consider. Also, speak to them. Speak to those people. You don't necessarily have to confirm with them that you're going to name them as your executor, but maybe just have a discussion with them in terms of if that's even something they would want to do. Because a lot of the time people are named, including myself, and then people pass away, you find out you're named, somewhat in shock, and then you don't really know if you want to act in that role for that person. Very important in Ontario is that the executor should be a resident of Ontario. Ideally, at a minimum, they should be a resident of Canada. So keep that in mind when you're picking people. Second important thing is who you would want, and probably the most important thing, who would you like to benefit under your will? So who would you like to give your personal effects to? We talked about that. Are there specific items you want to leave to anybody? So you could write them in there. You can have a whole list. You can have none at all. Or it can also be, I want my 3 kids to simply just split my personal effects. So it can be as complicated or simple as you want to make it. After that, is there any property? So if you own any property, do you want it, be given to a specific person, or do you simply want it to fall into what we call the residue of the estate, which is what everything else is? So that's kind of a primary plan. who's going to have my personal effects, who's going to have my property, and then who's going to take my monetary effects, assets rather. And you can understand most of the time could be the same people, or it could be different people depending on your circumstances, but very important things to think about. And also important, and you'll see in the handout, there are 3 different plans in terms of you should have at least kind of 3 scenarios in your will, or 3 scenarios that you're thinking about. And I'll give myself as an example. I am married with 2 young kids. So my primary plan, everything would go to my wife. If she predeceases me, everything goes to my children in trust. And then if they predecease me as well, then everything goes to my cousin's kids and my one and only niece, because I'm an only child. So this is what I mean here by primary plan, secondary plan, and common disaster clause, or clause of last resort. So very important you kind of cover all possible scenarios as much as possible, so that it's you making these decisions, not that those automatic rules that we talked about earlier. Now, another aspect you can add in your will, and something to think about, and this doesn't apply to everyone, but sometimes, especially in the common disaster scenario, you may want to think of some charities or not-for-profits that are dear to you, that maybe you were on a board of, or that you helped out during your lifetime. If your family were to pass away, maybe you want to benefit them. So that's something to think about. Obviously, those charities can be in any plan, and we see, it really depends on your situation. Very important to remember that when you're thinking of beneficiaries, it doesn't have to be who other people think would be best. This is really your chance to choose people. And what I always tell people is you won't be around anymore, so this really should be a personal decision to you. And I'll talk again about my own personal experience. I have a close friend who passed away, and his parents left him everything and didn't leave anything to his siblings, because his siblings had already had their share during their lifetime. So they had had many degrees, and their parents had paid for it all. So that's, my friend received everything. So that's all things you should consider when you're thinking of beneficiaries of your estate. So think of it a few different plans. Very important as well, if you have minor beneficiaries, that you think of a trust. So what a trust is simply a mechanism by which a third party manages money for either minor or adult children. And again, I'll just give myself as an example. Obviously, my kids were quite young. They're 5 and 8 currently. If I passed away tomorrow, and my wife as well, they wouldn't get any money right away. They would have it spread out over time. So that's something to think about. And when you go see a lawyer, he will discuss those options with you. But it's something you can start thinking about now. Is there a specific age you'd want your kids to get, their entitlement? Is there a better age? There's no perfect age. Obviously, everybody is different. Now, last but not least, is to think of people, if you have minor children, who would be your guardians in that scenario. And then if you want to push it one, if you've done your estate planning, you also should think about what would happen if you were incapable, who would make decisions for you. So that is C. And very important in Ontario, you can name these people. If you don't have anybody named, the government actually steps in to make decisions. So that's something important to cover if ever you are thinking of estate planning. And finally, this is something people don't do enough of, is who should be advised on your death. And you can have a list as broad or as long as short as you want it. But the overall message from me really is start your planning now. I'm 39 years old. A lot of my friends don't have wills, obviously. And, I try to push them, but they always just push it off to the side. The time is now. Doesn't matter what age you are. If you have a house or children or both, or any asset, frankly, you should have a will to manage all of that if something happens to you. Now, all my coordinates are there, but you can check out willsfromhome.ca if you want to learn more about estate planning. Thanks very much, everyone.